My Lords, House to be again in committee on the Passenger Railway Services Public Ownership Bill. Lord Hendy of Richmond Hill.
My Lords, I beg to move that the House do now again resolve itself into a committee upon the bill.
The question is that the House do now again resolve itself into a committee upon the bill. As many of that opinion will say content. The contrary, not content. The contents have it. In Clause 2, Amendment 7, Lord Moylan.
My Lords, I will speak to Amendment 7 and Amendment 9, which together constitute this group, and both of them are concerned with what the government says it intends to be the effect of the bill, which is the improvement of passenger services. And again, they are largely probing amendments, though we would expect that the bill should be amended, if not with a purpose clause, as proposed earlier by my noble friend Lord Gascoigne, at least with measures of the character contained in these two amendments, which seek to set a safety net, in effect, in different ways, for the services being provided. So the first one, Amendment 7, would have the effect that the relevant franchising authority has to give to the Office of Rail and Road, and it could be some other body, it could be the Department for Transport or whatever, if it's not the franchising authority, but it has to give to some trustworthy and credible body an assessment that the company that is going to take over the franchise is capable of doing so. Now, of course, what you might say to me is, what company? The company that is going to take over the franchise, as proposed by this bill, will be a shell company, an off-the-shelf company purchased by the Department for Transport, a perfectly ordinary company's law company, such as you or I might buy off the shelf. Well, that, I think, already starts to raise some questions as to why we would think they had any competence to run a railway. Oh, but you'll say, but don't be silly. That's just a form. The form is an empty shell company constituted under company's law, but the sole shareholder of that company is going to be the Department for Transport. In effect, if you look at it, they will say to me, it's the Department for Transport that is going to be running this service through the shell company that it's bought off the shelf in order for it to be the recipient of the public service contract, which is the only type of contract that the Secretary of State is going to be able to award. But I heard the noble Lord the Minister a little earlier in the debate, and I don't think I can pin it down exactly without looking at Hansard, but I don't think he'll deny he said it, that the whole purpose of the bill, well, not the whole purpose, it's true, but one of the main purposes of the bill was to take out of the Department for Transport a whole load of stuff they were no good at doing and give it to Great British Rail, because they would be better at doing it than the Department for Transport. So here we have a system proposed by the bill in which a service, the responsibility for operating a service, is going to be taken from a train operating company with decades of experience of providing the service, perhaps in some cases hundreds of years of experience of providing the service, if they are in fact a foreign railway company which is putting its foot into the British market and providing their services to us, taken away from them, given to a company bought off the shelf, which is owned and controlled by a department, which the Minister himself has said should have functions taken away from it and transferred to Great British Rail. What sort of a mess is this? And that is why this amendment very simply asks for an assessment in advance as to whether that company, that operator, is fit for purpose. It's not simply the shell company we're looking at, but of course its shareholders, its controllers, the people making the decisions. Why shouldn't the public have that level of assurance before a franchise is terminated and transferred to such an entity. That's what it's calling for, and I think there is a very strong case that it should be done. And the Second Amendment, number 9, is not the same, of course, but it points in a similar direction. Nothing is said in this bill about what level of service the new operator is going to offer compared to the old operator. It is, of course, for the Department for Transport, we think, or Shadow Great British Rail, we don't know. But it is for one of those two, presumably, to decide the terms and conditions of the public service contract which it is going to award to itself, if it is the Department for Transport or its shell company, or which it is going to award to the Department for Transport if it is Shadow Great British Rail. And somebody will have to sit down and decide what those terms and conditions are. And all that we're asking in this amendment is that those terms and conditions should not be lower. Those services, the services offered to the public, should not be of a lower standard than they currently are under the existing franchise. Now, that's not to say that there isn't the possibility of some sort of public consultation. That's what we've inserted. We have said that you can lower them, but you have to consult publicly in advance. At the moment, that would be true on the transfer of a franchise. We've had no assurance from the government that there will be a public consultation on the termination of a franchise and the award of a direct service contract, a public service contract directly to one of the Department for Transport shell companies. Now, I just terminate by saying that this is one of those issues where the government may want to say, aha, this is something which will all be dealt with by the great big bill coming down the rails towards us. And that, of course, would be a grave mistake, because these particular issues relate specifically to this bill and what is going to happen the moment this bill starts to be implemented. And as we've discussed earlier, this bill could be the governing statute of the operation of the railways for as much as 4 or 5 years, even if the government has a good headwind behind its new measures, and that they come forward in time and get implemented reasonably. So the public will want to know, are our service levels protected? Are we going to be consulted? And are the people who are going to be running these trains actually fit for it, when we know from the Minister he doesn't think that they're actually fit for much else on the railways?